please sit down. Thank you, Mr. Belstead. Yes, Mr. Futrell.
Yeah, mate, please, the Commission. Mr. Felsted, I want me to cast your mind back, your memory back to the Bergen inquiry, and you might recall you were asked a series of questions, or you were questioned at length regarding the Crown Resorts due diligence process concerning junket operations. Don't worry, I'm not going to make you relive that, but there are some aspects of it that have particular relevance to the Perth casino I want to ask you about. Just going to ask you, put some general things too, and if you don't agree, you can disagree or qualify them. From what I understand from the evidence you've given earlier today, at least by about 2016, the centre of the decision making as regards who junket operators would be, and I presume therefore junket representatives, were being made in Melbourne.
That is correct.
And do I also understand, not necessarily from what you've said today, but partly from what you said today and other evidence you've given in other times, that there was at that time, between 2016 and 2000, whenever effectively junkets ceased, there was loosely termed a committee, but really three individuals, Mr. Johnson, Mr. Preston and you, who were the ultimate decision makers as to whether a new junket would be approved.
That is correct.
And the three of you also had responsibility for reviewing any existing junkets if there were matters concerning probity that arose in respect of them.
That was a larger group, Mr. Futrell, that was done in 2016. So just in very brief, there was a review of every junket we had in 2016 after the detentions. That was myself, Mr. Johnson, Mr. Preston, and quite a few others, including Mr. Craigie. That group did its review, and then that group turned into a smaller group of myself, Mr. Johnson and Mr. Preston, who would do all new junket reviews.
All right. Now, what I was focusing on was after 2016, if information became available to someone within the Crown Group about the probity of an then existing junket operator, was it the case that you had an expectation that information would make its way to your committee of three?
Yes, or at least myself and Mr. Preston.
All right. For consideration as to whether, in light of that information, you would continue to maintain a relationship with that junket operator.
That is correct.
So as regards the decision as to which junket operators and junket representatives would be approved to carry out junket operations in Perth, at the Perth Casino, is the effect of your evidence that that decision was being made by yourself, Mr. Preston and Mr. Johnson?
Yes, in the case of new junkets, that's correct.
As part of that process, was there any reporting to the Burswood Limited Board as to a decision, first of all, at the end of 2016, after the review had been conducted, as to which junket operators had then been found suitable for you to continue to do business with?
No, there was not.
And so far as new junkets were concerned, was there any reporting to the Burswood Limited Board about decisions as to who had been approved and the reasons therefore?
No, there was not.
Was there any process by which, if you might like, if there was a borderline decision, someone who to which there was some information of a questionable probity, where you sought the authority from someone else within the Crown Group as to whether that person should be approved?
In terms of new junkets, no, we never really came across a borderline scenario. In the case of existing junkets, there were junkets that were escalated through to, I believe, the risk committee in terms of the dealings with those particular junkets.
When you're referring to the risk committee, are you referring to the Crown Resorts Risk Management Committee?
Yes, I am.
And so questions of that nature would not have been, as I understand the structure, been referred to the Perth Casino ERCC.
Not questions of that nature. That's my understanding.
So I'm just trying to, so in practical terms, any risks associated with continuing to operate junkets in Perth were not reviewed by Burswood Limited.
That is correct.
Can I ask, it'd be easier, Mr. Felstead, just to show you an exchange that took place between you and Commissioner Bergen during the Bergen inquiry. It's part of the transcript. It's at BGN.0002.001.1251, and the page references are 1331 to 1332. And as I said earlier, this I think really comes at the end of a fairly lengthy period of questioning of you, Mr. Felstead. And then the Commissioner asks at about line, sorry, I've got the wrong reference. At line, so it's 1331, the top right-hand corner of the ringtail reference, and it's page 1333 of the transcript at the bottom, so if that confuses anyone, it's certainly just confused me. But at line 25, it says, Commissioner, I get the impression. Do you mind?
Yes.
Just mind reading from there to the end of that page, and then over the page to the end of line 21, which ends, I'd be fully supportive.
So at the end of I'm fully supportive.
So it starts, my view would be that would be an Australia-wide process, and right through to the end of that passage, which ends, I'd be fully supportive.
Oh, yes, I read that.
All right, now, would it be fair to say that your view, at least at this time, and let me know if it remains the case, was that although the Crown Group had in place a due diligence process and probity checks on junket operators, you were accepting after the end of this questioning that there were some deficiencies in that process, in that media organisations and others were able to identify information about the junket operators that Crown was doing business with that were not available to you, or if they were available to you, were not being escalated to you for consideration.
Yes, I would agree with that.
And so the consequence of that was, in effect, that the Crown Group was carrying out junket operations with junket operators who had reputations for links to organised crime, or in some cases had been people who had been convicted of criminal offences.
That is correct.
And notwithstanding those reputational aspects of those junket operators, for one reason or another, neither you nor Mr Johnson nor Mr Preston had considered to cease carrying out the junket operations with them.
Sorry, could you repeat that question?
Notwithstanding there were these evident links, at no point, at least at the time you're giving your evidence, had Crown Resorts made a decision to cease operations with those junket operators.
With certain junkets, correct.
And the point I want to focus on is towards the end of that, you have indicated or expressed a view that there would be some benefit in having the regulators in each of the states, I take it to mean, Western Australia, Victoria, presumably New South Wales as well, have an active role in the approval process for junket operators.
Yes, I think the point I was making there, Mr Futrell, was I was looking at an independent body, and I would assume the regulator would be involved in that would review junkets and would get access to information that casinos can't.
And by that, do you mean, for example, access that would be available, let's say, to a law enforcement agency in Macau or Hong Kong or in mainland China about their junket operators?
Yes, that may well be the case. And a good example would be if we could get AFP, for example, to look at that. That would give us certainly information that we currently didn't have.
All right. So do I understand it to be your view then that you're expressing the view that junket operators require a more regulated approval process because of the risks associated with their connections with organised crime?
Yes, that would be a fair characterisation.
And do I understand effectively you to be saying that the casino operators themselves are not as well equipped to ascertain information about junket operators as government authorities are?
Yes, I am. So that is correct.
In your view?
In my view.
So do you recall, and can I ask you another question about that? For how long have you held that view regarding the extent to which you think it would be beneficial for a government authority to have a role to play in the approval of junkets?
It's been a while, and it was pre-Bergen inquiry. It was more about as Crown evolved and we did more and I guess increased due diligence. It was fairly apparent to me that there were gaps in that. We weren't getting information that others would get. And one of the things that we tried to set up was it was almost like I call it a casino working group, where you would get others from different agencies, whether it be AUSTRAC, whether it be AFP, various law enforcement agencies, to come to the party and assist in that process, because we were of the view that would have been something good for everyone, for the entire industry.
All right. Now, there was a time in Victoria in the early part, before I think 2010, when the Victorian regulator was involved in approving junkets.
Yes, that's correct. That's my understanding.
And there was also a time before 2010 when the West Australian regulator was part of the required approval of junkets.
Yes, I'm aware of that.
And do you recall that Crown Perth made a submission to the regulator here to remove the need for the regulator to approve junkets in Western Australia?
I don't recall it specifically, but I'm certainly aware of it.
Were you involved in the decision to make that submission to the GWC in 2010?
I can't recall.
And insofar as the view you just expressed concerning the involvement of a government authority, was it a view you held in 2010, or is it something that developed after that?
It's probably developed more post that, in terms of the early way of vetting junkets was quite rudimentary. As time went on and we got a bit more sophisticated, we had access to third-party databases and the like. That's when I probably paid a bit more attention to that. But around 2010, probably didn't have this view.
All right. Now, I want to ask you another question, which is something about which I really don't understand. So, if I could ask that we call up CRL.540.001.0114, which is it's a statement I think that stood as your evidence in chief in the Bergen inquiry matter, but it was in respect of a proceeding in the federal court.
Yes.
And if we could navigate it to page 0116 and paragraph 7 of that statement.
During the relevant period?
Yes, and which is that 15-16 period we dealt with earlier today.
Yes.
And I'll let you finish reading it, Mr. Felsted.
Yes, I've read that, Mr. Futrell.
I've got a number of questions for you about this, and you may not know the answer to all of these. The first is that your view you're expressing there about it being a small portion of profit and a low margin component of Crown Resorts business correct as of your evidence today?
Yes, it is.
And was that the case to your knowledge in respect of the operation of international commission business for the Perth casino in the period before the PBL takeover?
In the very early days of, call it Burswood, my understanding was the junket business and the premium player business, or ICB, was a much larger proportion of their overall business.
Larger proportion of profit? Is that what you mean by that?
And I'm based on numbers that I've seen a long, long time ago. It would have been profit. They would have been a far greater percentage of profit back then than we were now.
And does that similarly apply to the margins in respect to the business?
ICB has always been a low margin business, but what happens is back in the day in Burswood once again, they were getting large volumes, which obviously the more volumes you have, the better you're going to do from a profit perspective, but it's always been a low margin business.
I see. So the question I really have from a financial stability and business perspective is I think first, if I could say, I'll put this proposition to you, which I think you have already accepted, which is that the international commission business comes with a risk of criminal infiltration.
Yes, I accepted that.
And so it creates a risk for the casino operator in that regard. It's a low margin component of the business.
Correct.
It delivers a small portion of the profitability. In what way and for what reason, if you like, was it seen as a component of the Crown Group's business? In other words, was the game worth the candle? Why was the game worth the candle?
The game worth the candle. Yes, it was still a profitable part of the business. It still made money. It was still a valuable business unit, but I guess the opportunity for Crown was if we could grow the business, that would flow on. But it's still, regardless, so an example would be, if I can use Melbourne as an example, the hotel business, for example, in Melbourne, was traditionally larger from a profit perspective than the VIP business. Now, it's still a valuable business, but it's not at the scale of those. So it's still worth pursuing, in our view, but it was never at the scale of local gaming.
At the scale of local gaming, meaning?
Profit-wise.
Now, local gaming I understand to mean is that include table games and the electronic games, does it?
Yes, it does.
You might recall another matter I asked you briefly about earlier, which is, again, something I need you to assist me to understand, if you don't mind, Mr. Felstead, which concerns the cheque cashing facility. And in this regard, could I ask that we call up CRW.529.002.0136, which is what I understand to be a portion of the casino manual operations, and this concerns Section 3, capital A, Main Bank. Now, I don't know if you're familiar with the detail of these documents. If you're not, that's fine. I don't want to ask you about the detail. I want to ask you about the process. It's not okay. We don't have it anyway, so I'll just ask you about the process.
Sure.
Sorry, my apologies. It doesn't seem to have been loaded. So you mentioned earlier, and I think this was in connection with the credit for your credit teams identifying if someone were creditworthy to extend credit to them, and you draw a distinction between international players and the VIP, international business, and domestic. And the reason being, the only credit that's extended to domestic players is via this cheque cashing facility.
I wouldn't call it credit, but I see where you're getting at.
Sorry, okay. Well, it is not patently obvious from reading the casino menu how this operates as a matter of practice. So are you familiar with the way in which it works as a matter of practice?
Yes, I've got a working knowledge of that, yes.
All right. So if a patron wishes to access, and I'm now talking about a domestic patron, the cheque cashing facility at the Crown Perth Casino, what do they need to do in order to access that facility?
Right, what they would need to do is to fill in an application. Let's say all the application's done, we do KYC, we do the usual checks, and then we would go and do a creditworthiness check on them. Typically, many years ago, that used to involve getting information from the bank. We would look at their wealth, and then we would say to that particular patron, yes, you've been approved for call it a $5,000 cheque cashing facility. The patron would go yes. They would come to the casino. They would need to produce a cheque, one of their own cheques in the first instance, so like just a normal cheque, which I'm not sure how many people use anymore. They would produce a cheque, and that cheque would be transacted on their account.
And in that scenario, they present to the casino a personal cheque drawn on their own bank account. What is the nature of something referred to as a house cheque?
House cheque. That's in the case where the customer doesn't have a cheque on them. So for the first time they use the account, they must produce their own cheque. This was the policy back in the day. When they come in after that, they can use a thing known as a counter cheque, which is a house cheque. And what that is, they would go up to the cage, cashier prints in, Mr. Smith, I'd like $2,000. That will print out a document, which is a counter cheque, which has got the bank name, the BSB, the account number. It's a replica of the cheque, just not in the same format as the bank issues it.
I see. And let's say the patron has an unsuccessful outing to the casino and loses the $2,000. What then happens with the house cheque?
That would be held in the main bank area, I believe, for typically, I think it's about between 5 and 7 days to give them a chance to redeem it. If they didn't redeem that cheque, that would go to the bank and get banked.
So the house cheque, as it were, is a negotiable instrument that you can present to the patron's bank and receive the proceeds of that cheque.
That's certainly how it worked when I was in the cage, yes.
Okay. Now, in the course of the initial establishment of the cheque cashing facility, the patron arrives with a cheque for the limit of the facility. Is that the gist of it?
I don't believe so. I think the rule was, this is back quite a while ago, was you had to produce a cheque for the first transaction you did. It didn't have to be for the full amount of the facility.
I see. And who made the decision, and let's break this down into time periods again, because I think you said that from, 2016, the credit function had moved to Melbourne.
Yes.
So when a person wished to obtain a facility, who in Perth, the Perth Casino, if anyone, undertook the credit check on that patron?
And this is post-2016?
Yes.
No, that would have been... Look, my understanding, and I could be wrong here, because I know how it worked for international, I think for domestic it was still done out of Melbourne. That's my understanding.
From 2016?
Yes, I think that's correct.
And prior to 2016?
Prior to 2016, I believe it was done through credit control department in Perth.
All right. Now, patron arrives, wishes to have, say, $10,000 in credit, produces a cheque of some description, presumably to obtain some credit. And if, again, they have an unsuccessful outing at the casino, and at some point during their session they wish to increase the limit, is it possible to do so?
Yes, it is. It's called you stretch my memory here from my cage days, I think it's called a TTO, this trip only.
All right. And is there a limit on how much a person could, additional credit could be obtained via a TTO for anyone?
Yeah, I think the witness said that he wasn't speaking about credit, so
Sorry.
the question could be rephrased.
So my apologies. Was there a limit on how much the credit cashing, the cheque cashing facility could be increased?
The rule that I can recall, it was a maximum of 50%. That was the general rule, but on occasion it would go over, on occasion it could be a smaller amount.
And who had authority to approve the increase in the facility at that time? In other words, during a session?
During a session, there was a matrix of people who could approve. It would typically be someone of the vein of the table games manager, for example. Depending on the amount, it could be the COO, it could be the head of gaming, it could be me for a certain amount. It just really depended on the limit.
So, and am I right in thinking a TTO would involve the issuing of a house cheque?
Typically, that would be correct.
All right. So let's assume at the end of the particular session, the patron's been very unsuccessful from his perspective and very successful from yours, and has managed to lose the initial amount of the extended for the original facility, plus the TTO. At what point are the accounts settled? As the person leaves the casino, or at some other point?
No, in that scenario, if we made the assumption that there was a $10,000 cheque firstly, a $5,000 cheque, both house cheques, counter cheques, they would be both the $5,000 one and the $10,000 one would be treated the same. So they would be held for a period of, I think it was 5 to 7 days, and banked after that.
So in respect of the additional component, as in the increased component, insofar as the original credit cheque goes, the casino no doubt would be satisfied that the customer, that the patron, was good for the 10,000, as it were.
Yes.
In what way would by what process would the casino be satisfied that they are good for the additional 5?
Typically on the not the credit profile, the cheque cashing profile for the patron, it would say, quite often they would have a limit on there that they could TTO to. So some may have a notation on there, no TTO. Some may have a notation up there, TTO approved to $15,000, $20,000, whatever it might be. That was one of the ways that the staff making the determination whether they grant such a TTO would look at.
All right, so it's theoretically possible then, is it not, with this process by which you produce house checks and with TTOs, that when the casino goes to present the house check to the patron's bank, there are no funds available to satisfy the instrument?
Yes, that's correct, and that would be the same for when a player in the first instance may produce one of their own personal cheques. There may be no funds available, or the player may have stopped the cheque for whatever reason.
Yes.
Sorry, in that, that you talked about a redemption, that you hold the cheque, be it the patron's cheque or the house cheque, you hold it for 5 to 7 days. If it's not redeemed, then you bank it. What was the usual process for redemption? By what means would they come in to redeem?
Normally, Commissioner, they would do a telegraphic transfer, or they may come in with a bank cheque. That was another way they would do it on occasion. Typically, it would be a telegraphic transfer, or in a lot of instances, the patron was quite happy for the cheques to be banked.
Okay, thank you for your assistance, Mr. Felstead.
Apologies, that was a long time ago I was involved in that, but
To your knowledge, was the system any different during the period you were CEO of Crown Perth?
no, I think it was roughly the same.
All right, now, can I ask that Mr. Felstead be shown another document? This is, I think it's GWC .0002.0016.0260, and starts at page 14. All right, now, Mr. Felstead, this is not your letter. Just to make this clear to you, I think it's Mr. Preston signed it. But if I say to you that the Crown Perth responded to some inquiries the GWC had made that arose out of the Victorian Regulator's 6th review, would you know what I'm referring to? There was a response to that.
Yes, I would.
And I'm not so much interested in your knowledge of this letter at the time it was sent. Just I would like you to draw your attention to some aspects of the overall explanation of Crown Perth's responsible service of gambling program at this time, and get your understanding of whether you accept it reflects the view of yourself as a CEO at that time. So, if I may draw your attention to, and if you wish to, Mr. Felstead, you can take your time to read the whole document. But at this stage, I want to draw your attention to page 29, 0029, and there's a heading that begins Other Harm Minimisation Strategies.
Yes, I have that here.
And in particular, I want to ask you some questions around the first one referred to on the top of the next page. Perhaps if the operator could put these two pages side by side, it would assist. Now, the author of this letter, Mr. Preston, was indicating to the GWC that one aspect of Crown Perth's harm minimisation framework included limits on automated teller machines. And he makes reference to the $400 withdrawal limit and the fact that that the ATMs were located 40 metres away from the entrance of the gaming floor.
Yes.
So you know what it means by the limits on the automated teller machine?
Yes, I do.
And does this reflect your view as of 2018 that one feature of the Crown Perth responsible service of gaming framework was that there was a level of restriction on patrons' ability to withdraw funds in the gaming area?
Yes, it does.
And can I ask you to draw your attention to the next heading, which is the gaming machine standards. There's a reference there to the prohibition under the Casino Control Act to the approval of games played with poker machines.
Yes.
And so as of November 2018, did you understand a feature, or did you consider a feature of the responsible service of gaming framework for the Perth Casino to be that part of the regulatory framework prohibited the use of poker machines at the Perth Casino?
Yes, with a qualifier that I was always aware, obviously, poker machines couldn't be used in the casino or anywhere in the state for that matter. That was the responsible service of gaming component of this was a smaller one. It was not a key one, but it was nonetheless an element of it.
And what you say is a smaller one, not a key one. What do you mean? Are you making reference to the fact there were EGMs on the gaming floor, therefore there's an element of electronic gaming taking place?
No. What I was referring to there was there would have been other things which I would have seen as a larger RSG influencer than the particular machines that we had compared to poker machines.
Okay.
Or features of those machines.
And then can I just draw attention on the next page under the heading Speed of Play, it's italicised.
Yes.
Now, as of November 2018, was it your understanding that one aspect of the responsible service of gaming framework for the Crown Perth Casino was that under the Australian standards that applied to Western Australia, there was a slower speed of play required for electronic game machines used at the Crown Perth Casino?
Yes, I was aware of that.
And was it your understanding that the reason it was considered to be part of a responsible service of gaming framework was that the longer interval between, the longer interval of speed of play, in effect, the less games a patron can play in a given period of time?
That's correct, yes.
And one other feature of an electronic game machine is there is essentially an inbuilt margin to the house, if I could put it that way.
Yes, there is.
So, in effect, the slower a player is able to play, on average, the less they're going to lose within a particular window of time.
Yes, that's correct.
And conversely, the faster a person plays a game, the more they can lose in the same period of time.
That's correct. Or they would lose a similar amount, depending on their wallet, in a shorter period of time.
Yes. And so it's a feature of a responsible service gaming program because it provides a check against or a balance against the amount an individual can lose in a given period of time.
Yes.
Now, were you aware that Mr. Preston had provided this response to the GWC in 2018?
I don't recall this.
All right. Now, could I ask you to be shown GWC .0002.0016.0281? And can we scroll? Again, I can't. The number I think is 0003. It's obscured by the reference to the attachment.
Yes, dear Mr. Ord.
Dear Mr. Ord, and you'll see there's a ref with your name, Mr. Preston's name. I could just ask you to scroll down to operator to the end of the letter.
I signed this.
Yes.
I'm aware of this.
Yes. So do you have a clear recollection of this event or the process of seeking an amendment to the WA appendix in the early part of 2019?
Yes, I do.
I just want to draw a couple of things to your attention. You no doubt recall that one of the aspects of this application was to reduce the speed of play from 5 seconds to 3 seconds.
That is correct.
So in a period of less than 6 months after the earlier letter, where Mr. Preston had been expressing it as a virtue of the responsible service of gaming, you were applying for the GWC to approve effectively an appendix that would increase the player's speed of play.
That's correct.
And therefore would increase, in the way we've just described, the ability of a person to lose more in a shorter period of time.
In isolation, that's a correct statement.
Yes. So I just want to ask you, there's a passage on page 9 where under the heading responsible service of gambling. So you have clearly did turn your mind to this. What I'm interested to know is in the first part of the second paragraph, there's a reference to expressing a view that the proposed amendments will not have any impact on gambling-related harm. Now, first of all, is that a view that you held in March 2019, to your recollection?
Yes, that was my view.
And does it remain your view now?
Yes, when it's taken into context, which I'm happy to elaborate on later.
I'm going to give you that opportunity. So,
Excellent.
So you've expressed that view. Now, what was the foundation for the view you expressed as to the not having any impact on gambling-related harm?
Yes. Firstly, I think the words will not have any impact on gambling-related harm is incorrect. It should have been minimal. And I think you'll find that I did a presentation to the GWC which stated that. So that should not have read any impact. It should be minimal impact or negligible as a starting point. So that was incorrect, but that was corrected when we gave the presentation. And sorry, the rest of the question was?
Well, then, given the words should read would have minimal rather than would not have any, what are you trying to convey to the reader by that the words minimal impact? So why did you have the view it would be minimal impact?
The reason I had the view it would be minimal impact was that we currently had the majority of our machines on the floor were a new type of machine. So they were machines with a feature in it. and this is quite a reasonably lengthy explanation here. If you go back to 15 years ago, all the machines on the floor were very, very basic. Most of them didn't have a feature on there. They were a draw card, draw poker machine, a keno machine, that type of thing, with a 5-second spin cycle. Very, very simple. As time evolved, the machines evolved, and the machines came with features. What that would mean is you would play a machine, and instead of just a result coming up, quite often you get a feature. And a feature could last anywhere from 30 seconds to a minute to 2 minutes, depending on the machine. So what that actually did...
Sorry, can I stop you there?
Yes, sorry.
What is a feature?
Oh, a feature. When you're playing a machine, I'll use the example of an Eastern States machine. When you're playing a typical poker machine, reels spin around and you may have 3 symbols, say 3 dragons, for example. That will give you free games. What will happen when you trigger that, you'll get free games. Typically, you'll get 10, 12, 15, 20, 25 free games. And what that does, the player has no interaction. The reels spin, and whatever you get off those free games goes to the credit meter. So that lengthens the experience of that particular spin by a long, long way. So what we were finding here was, as we're getting these types of machines with features, because the manufacturers weren't making old-style machines anymore, all the machines had a feature, whether it was free spins, whether it was a jackpot, whatever it might be. That increased the actual spin rate on average to about 9 to 10 seconds. So we've gone from 5 seconds, which was mandated, which was fine. It's gone to about anywhere between 9 to 10 seconds on average. So the length of time between spins on average for a player was much, much longer. That's the reason we went to do that. We didn't want to go back and say the old style machines, which were 5 seconds, we'll go and convert those into 3 seconds. Any new ones we would, but the reality is manufacturers and casinos don't buy old style machines that don't have a feature, free games, jackpots, that type of thing. That's the reason for this in the first place, because our spin rate blew out from 5 to about 9.5 to 10 seconds, which I think I explained earlier in this particular note.
All right. So if I've got 2 questions for you that arise out of part of your answers there. The first is, if the spin rate, as you described, blew out to 9 seconds, isn't that a positive effect then on player harm? Because it effectively doubles the spin rate and therefore halves the amount of games that can be played in a given period of time.
Yes, you could say that.
So if manufacturers were designing and building games with these features in it, one could see that as a positive outcome for responsible service of gaming that has been negated by decreasing the spin rate.
Yes, you could say that.
All right. So just so I understand. The second is, I thought I heard you answer earlier, partly an answer, that there was a poker aspect to the game. I can't remember exactly what the words you used, but do you mean by that there was a poker machine or some other form of poker?
No, what I was referring to in the early days of Burswood, pre-PBL, the machines you had there, they were a draw poker type of game. So you play a machine and there'll be a series of cards on there, ace, king, queen, da-da-da-da-da, and you try and get a result off that. Or they were a simple game that balls would drop down as per, call it a bingo keno type of game. So there were no machines that you would see on the East Coast in any iteration over here as a poker machine. These are they were a pure gaming machine unique to Western Australia, and they were set at 5 seconds.
All right. Now, could I ask you to be shown CRW.008.044.0236? And if we could scroll to page 0236. And again, if the operator could scroll through the letter so that Mr. Filsey can see the signature page. And if we go back to the start and just the subject matter of the letter. Can I ask you, Mr. Felser, do you recall this submission to the GWC concerning cashless payments?
Yes, I do.
Now, with respect to responsible service of gaming, you'll recall I took you earlier to the description of the ATM machine restrictions in the earlier period, whereby there was a limit of $400 and they were not within 40 metres. You recall this proposal involved something different. You could obtain essentially cash within the casino through the FPOS process.
Yes, this was at a gaming table.
At a gaming table. Now,
Yes.
can you, in respect of this proposal, do you consider it to have any impact on responsible service of gaming?
When we put this proposal up, or when we thought about this initially, that was obviously one of the key considerations we had, because I thought it was that could have been an issue. We looked at the circumstances around this and some of the procedures we had in place. We got a third party's opinion on this, or what we believe an expert opinion on this, in terms of would this have a significant effect on responsible service of gaming negatively.
So just in respect of that, first, who was the third party from whom you obtained the advice?
Yes, Crown, I think it was back in 2019, engaged the services of and this would report to our responsible service of gaming board committee. We engaged the services of three, I guess, I don't like to use the word, I guess you call them responsible gaming experts. There's a gentleman by the name of Alex Blasinski. There was Leah Nauer, who was based in, I think, Canada, and a chap by the name of Professor Paul Del Fabro, who was a responsible gaming expert from, I think, South Australia. We wanted to put an expert panel in place, and we engaged those people, and their job was to give us advice on, firstly, our responsible service of gaming framework, our policies, our procedures, and this is one of the first issues that we ran by, whether it was that group entirety or Mr. Blasinski. We got advice, and that refined how we did this.
All right. Now, are you able to recall and explain to the Commission your understanding of the differences between the position under the what I'll call the ATM policy and what applied upon approval of the FPOS facility?
I might need you to rephrase that, please.
What do you understand the differences? What were the differences between the ATM policy, which required a restriction of $400 limit on withdrawals and 40 metres outside the footprint of the casino, and what was the difference here with an FPOS facility at the gaming tables?
All right, apologies, I understand the question. What would occur in this one is you could take out, I believe it was $400 on per transaction. I think it was $400 per transaction. I need to refresh my memory. That could only be done on a debit card at the table via a PIN pad. So there was interaction with the dealer. So it wasn't an anonymous transaction. There was interaction with the dealer. They would process a transaction. They would give you a voucher, call it a chip purchase voucher. The voucher would be exchanged for chips. The voucher would be accounted for, and that would form part of drop.
So do I understand the essential difference to be, based on that answer, that instead of the patron having to get up and physically leave the casino and go to an ATM and make a withdrawal, they could do it at the table?
That's correct.
And did this apply equally to electronic gaming machines and to table games?
No, it hadn't been rolled out on EGMs. I'm not sure whether we actually had it. I'm not sure whether that was going to get done in the future, but there was no. This wasn't available on an EGM.
And if a person was playing EGMs at this time, would it be open to them to go to the cage and use their FPOS at the cage and obtain ticket in, ticket out vouchers to use on a gaming machine?
Yes, Yes, I believe that's correct. They could do that at whether it was a ticket in, ticket out voucher or cash, I don't recall, but they could do an FPOS transaction at the cage.
All right, now, you, in the course of your time as the CEO of Crown Perth and Australian Resorts, you had contact with Mr. Sargent from time to time,
Yes, I did.
and Mr. Sargent at that time was the Director General of the department that regulated the casino in Perth.
Yes, he was.
And he was also,
Sorry, what time was this?
when you had contact with him as the CEO of Crown Perth.
Sorry, throughout that whole period.
Yes.
Sorry. Yes. Yes.
I think what my friend is saying is that Mr. Sargent, at one point, possibly during the time you were the CEO, ceased to be the Director General of the department, I think towards the end of 2007.
Oh, apologies. Yes,
2017,
he
I
did,
think
yeah,
it was.
Mr. Sargent.
Yeah.
I think he retired.
But you understood him to be up until the point he had ceased to be the Director General,
Yes.
and the Chair of the GWC.
Yes.
And after he ceased to be Director General of the department, he took up a role as an ordinary member of the GWC.
Yes, I believe that to be correct.
All right, now, I just want to ask you some questions about your relationship with Mr. Sargent. Mr. Sargent accompanied you on a trip to Melbourne in 2012.
I don't recall him accompanying me. I believe I certainly have a recollection of. I think it was in my statement that I met up with Mr. Sargent in Melbourne and Mr. Connolly, but I'm not. I don't recall him accompanying me.
I see,
Yeah.
but there was a visit by Mr. Sargent and Mr. Connolly to Crown Melbourne for the purpose of observing the ticket in, ticket out process in Melbourne.
I don't recall, but that would sound about correct. Yeah.
And the Crown Group paid for the flights and accommodation of Mr. Sargent and Mr. Connolly on that occasion.
Oh, I'm not aware of that.
Okay. Mr. Sargent also travelled to Macau in 2013. Do you remember that?
Yes, I do.
And the purpose of that was for him to be educated about the competition that Crown Perth was facing from the casinos in the region.
That's correct. Yes.
And Crown paid for his travel and accommodation on that occasion.
Crown definitely paid for his travel. I don't recall if it paid for his accommodation, but definitely paid for his travel.
And did you accompany Mr. Sargent on his observations of the competition whilst in Macau?
Yes, I did. Yes.
And were there occasions when you went to entertainment with Mr. Sargent?
I would have had dinner with Mr. Sargent. I believe I said in my statement we saw a show. That was about the extent of the entertainment.
Do you remember the name of the show?
It was at City of Dreams, which was our sister casino, and it was called House of Dancing Water.
Okay. Were the tickets to the entertainment paid for by Crown?
I don't recall, but more than likely, yes.
And do you recall the dinner, where the dinner was?
No, I don't recall where the dinner was.
And again, was the dinner paid for by Crown?
I don't know. I don't recall that.
The purpose of you actually extended an invitation to Mr. Sargent for this trip, didn't you?
Yes, the circumstances were I was talking to Mr. Sargent. I can't remember which format, and I was talking to Mr. Sargent, and I said, are you planning on going to Macau anytime soon? And he said, look, that'd be a good thing. I believe he checked with his minister, and there was no funding for it. So I said to Mr. Sargent at the time, I said, this is something that we would be prepared to pay for from an airfare perspective. And then Mr. Sargent obviously went off and got approval, and that's how the trip eventuated.
The purpose of the trip, though, was to educate Mr. Sargent about the competition in the region, correct?
Yes, it was. I thought it was necessary for someone of Mr. Sargent's seniority and role within gaming regulation of the casino to know what's going on in the region. I thought that was very important.
And around the same time, Crown was formulating a proposal, or had formulated a proposal, to make to the state government to reduce the amount of tax on international commission business. Correct?
That is correct. That process kicked off in, I think it was 2011. That was about a 3-year process. So that would have, Mr. Sargent's trip would have occurred during part of that process.
And it was part of the process, wasn't it, to assist with the act of persuading the government to reduce that, to educate the Director General of the Department about your competition?
Sorry, could you just repeat that again?
Well, part of your process of persuading the government that there was a need to reduce the tax involved educating Mr. Sargent about your competition.
Yeah, it would have been, yes, that was definitely part of it.
Yeah, you were hoping to persuade him to your cause, in other words, that look how difficult our job is with all our competition in the region.
I'm not sure I would have actually phrased it like that, because this particular proposal for tax went through Treasury, so we had to present to the Treasurer, Minister for Racing and Gaming, and the department. So there was other people involved in that. It wasn't just as simple as Mr. Sargent saying, yes, I do it.
But it wouldn't have hurt it if Mr. Sargent was on your side on this, would it?
Oh, look, I mean, I never regarded Mr. Sargent as being on anyone's side, certainly not the casino side. I've had a lot of experience with Mr. Sargent. That's not how he operates.
Commissioner, to give you one moment.
It's only a couple of things, but I don't think that you need to. Yeah, I think so. Come back.
Mate, please, the Commissioner, I have no further questions.
Thank you, Mr. Futrell. Are there any applications for leave to cross-examine?
Yes, Commissioner. I may
Mr.
come from the back row.
Penglis.
I seek leave to cross-examine Mr. Felsted with respect to the evidence he gave just before lunch about a conversation with Mr. Preston about his conversations with Mr. Brown and no credible explanation for the aggregation.
Thank you.
Mr. Can you see me in the back?
I
Mr.
can just
Felsted,
see
my
you there.
name is Penglis and I appear for Mr. Preston.
Nice to meet you.
Now, you'll recall just before lunch you gave evidence about conversation that you had with Mr. Preston after he gave evidence in the Bergen inquiry on the aggregation issue, correct?
That is correct, yes.
And I think you said this, well, just before lunch, that Mr. Preston said he had spoken to Mr. Brown and some cage staff, correct?
That is correct, yes.
And I think it was your words that you used the word that there was no credible explanation provided to Mr. Preston so far as he was concerned. Is that correct?
That is, yes, that's what I said, yes.
All right. Now, you're aware, aren't you, that Mr. Brown gave evidence in the Bergen inquiry?
Yes, I was aware of that.
Yes. Now, Commissioners, I'm going to refer to some transcript. I'm told that it's not been uploaded yet. It's Mr. Brown's evidence. I'll refer to the transcript page, but it's not before the Commission at the moment.
Thank you.
Now, I just want to, Mr. Felsted, read to you a couple of portions from the transcript of Mr. Brown's evidence and just ask you some questions.
Certainly.
All right. Now, you know that Ms. Orr was counsel for Crown in the Bergen inquiry? One of the counsel?
One of them, yes.
Yes. I'm reading, for the purpose of the transcript, I'm reading a transcript of 4 September 2020, page 2138. Now, Mr. Felsted, Mr. Brown was asked whether he recalled being questioned about work done by the cage staff in Crown Perth in the period 2013 and 2016 in relation to transactions on the Riverbank bank account. Mr. Brown said he recalled that. And then Ms. Orr asked him this, and you said in answer to one of the questions that you believe the Crage staff at Crown Perth were aware of their obligations in relation to anti-money laundering. Do you recall that? And Mr. Brown said, yes, I do. And then Ms. Orr asked, would you please explain for the inquiry what those obligations were? To which Mr. Brown responded, the cage staff under anti-money laundering are required to review any transaction to ensure that patrons are not doing anything that they perceive to be outside of guidelines and to report anything that they believe to be suspicious. Now, as the CEO of Australian Resorts at the time, did that accord with your beliefs and understandings?
Yes, generally, yes, it does.
Thank you. Further down then on page 2139, Ms. Orr continued to ask Mr. Brown some questions, and it was, how were your staff made aware of their obligations that you've just explained? To which Mr. Brown answered, they were made aware through their ongoing training and ongoing annual training in regards to any sort of suspicious matter. Now, just pausing there again, as the CEO of Australian Resorts at the time, that would have accorded with your expectations and beliefs?
Yes, it would.
Thank you. Ms. Orr then asks, and did that online training, to your knowledge, deal with the concept of structuring? Now, you, I think this morning, said that in your terminology is smurfing, correct?
That's correct,
But
yes.
you understand the structuring and smurfing are effectively interchangeable?
Yes, I do.
All right. To which Mr. Brown responded, yes, there is a component in there in regards to structuring of payments, yes. Now, again, as the CEO at the time of Australian Resorts, that would have accorded with your belief and understanding?
That is correct, yes.
Now, I want to go back to some earlier evidence that Mr. Brown gave, and now I'm reading from transcript page 2132. You recall that Ms. Sharp was one of the counsel assisting the Bergen inquiry?
Yes, I'm very familiar with Ms. Sharp.
Sorry?
I'm familiar with the Ms. Sharp.
Thank you. And so Ms. Sharp asked Mr. Brown this question, to the best of your knowledge, in the period 2013 to 2016, is it right that the people at the Crown Perth Cage who did look at these actual bank account statements for Riverbank were not looking at whether structuring or smurfing was taking place within those accounts? To which he said, no, I don't believe that to be the case. No. What's your reaction as the then CEO of Australian Resorts to...
Sorry, could you just repeat the last one? No, as in I don't...
No,
It
in the
is
sense
now
they
on
weren't
the
doing
screen.
it.
Oh, thank you. That makes it much easier.
Oh, good.
It's at about line 35.
35.
I think you should read it, Mr. Felsted, as an agreement with the proposition that they didn't look at the bank statements. We can see that from the next...
Well, I'll
sentence
just,
of the
if I could just,
answers and clear.
so 35.
See in the left-hand column, there's a number 35.
Oh, yes, thank you, Commissioner. Yes, I see that statement here. That would not accord with my understanding of what instructions were.
Thank you. And then later down, Ms. Sharp asks, did things change at all in that respect after 2016? You can see the answer. You can read it now for yourself rather than hear me go on. Under that, Mr. Brown, and then over the page, please, operator. And you'll see that Mr. Brown effectively said that, so far as he was aware, he was not sure whether there was any change or whether there was any specific instruction.
Okay.
So what do you say to the suggestion that effectively from 2013 through to and including the date of this evidence, 4 September 2020, the cage staff at the Perth Casino were not looking at whether structuring or smurfing was taking place within those accounts?
That would be a surprise to me. I would suggest that the evidence that Mr Brown, what I've been heard from yourself, gave to Ms Orr was an actual statement of what was occurring. The information he's given to Ms Sharp, I just think he's incorrect here.
May it please the Commission.
Thank you, Mr Penglis. Any other applications? Mr Ward.
Commissioner, I seek leave to cross-examine on some matters arising out of Mr Felstead's statement relating to the operation of Burswood Board. Mr Felstead, I appear for Mr Poynton in this inquiry.
Thank you.
Can I ask you first, this isn't clearly dealt with in your statement, but I just want to clarify which functions of Crown or Burswood were dealt with at the national level rather than the local level. So perhaps if I could just run through some of these functions. Finance was dealt with at a national level by Crown Resorts?
Finance as in budgeting, you're talking about?
Yes.
Budgeting was ultimately approved at the Crown Resorts level, yes.
The overall budget for the Crown Perth was dealt with by Crown Resorts Limited Board?
That was approved by the Crown, the Crown Resorts Board, yes.
IT services were all dealt with nationally?
That's correct, yes.
And marketing was all dealt with nationally?
Yes, but I'll qualify those statements. That was done after, I think we started to amalgamate or have group functions around 2016, 15 on. So it wasn't always the case, but it used to be the case that Crown Perth had its own marketing department, its own finance department, own IT department and the like. Then it became a group function.
It became a group function.
Yes.
Thank you. And hotels were also a group function?
Hotels were a group function, that's correct.
You've already mentioned the VIP stuff was all managed out of Melbourne. That's right?
Yes, after that particular period of time, correct.
And a lot of the HR services were managed out of Melbourne.
No, yes and no, and I don't want to be vague here. We had a dedicated human resources manager in Perth whose only role was to look after Perth. We had a dedicated human resources manager in Melbourne whose only role was to look after human resources in Melbourne. We did have some group roles around occupational health and safety, around our Indigenous employment program and around our disability program, and there may have been a couple of others, but so there were elements of it which were group, elements of it which were local.
And of those group functions that we've talked about, a lot of those reported up through to board committees of the Crown Resorts Board, didn't they? So perhaps if I can give you some specifics. You're aware that the Crown Resorts Board had an audit and governance committee?
Yes.
And that audit and governance committee was responsible for the internal and external audit programs ultimately, wasn't it?
Yes, that was it. They had overall responsibility for that.
They set the framework for the audit programs.
Yes, they approved the framework is a better way to describe that.
They approved the framework that was recommended up by executive management.
That's exactly right.
Thank you. There was also a finance committee of the Crown Resorts Board that dealt with financing issues relating to the operation of the group.
I wasn't a part of that, but I believe there was, yes.
You're aware that there was a responsible gaming committee that was chaired by Professor Horvath at group level?
Yes, I am.
And that responsible gaming committee had overall supervision across the group of responsible gaming policies and frameworks?
Yes, from a policy and framework perspective, yes.
And a risk management committee that was chaired by Mr Dixon and then later Ms Holton, who had overall supervision of the risk framework across the group.
And yes, an approval of such.
Yeah. Now, you mentioned in paragraph 41 of your statement the risk management framework. The risk management framework was then applied by the ERCC, wasn't it?
Yes, yes it was.
And you say in paragraph 40, I think it was. That, sorry, apologies, I've referred to the wrong paragraph number. Paragraph 43, that the ERCC assisted the board of Crown Resorts Limited in the final sentence.
The ERC's role was to assist the Burswood Limited Board to monitor risk and compliance.
So that was by the ERCC carrying out assessments of risks in accordance with the framework set by the Risk Management Committee of the Crown Resorts Board, and then reporting upward through to that Crown Resorts Board ultimately, wasn't it?
Yes, they were also would be informing the Burswood Limited Board of developments around that by the way of a legal risk and compliance pack which would go into the board packs.
You would receive that the legal risk and compliance report for the board pack before the rest of the board received it, and you would review that in your capacity as CEO?
Yes, typically yes.
And when you reviewed it, you would ensure that it not only presented issues that had been identified, but also presented the solutions to those issues for the benefit of the board of Burswood Limited, wouldn't you?
Typically yes, I will give an update on, and that may be the following board meeting. So if there are issues raised in board meeting number 1, I would typically apply a follow-up in the following board meeting, or sooner if need be.
And if there'd been any issues identified by the Burswood Limited Board, they were raised upward to the Crown Resorts Board?
If there were issues raised of this nature in the Burswood Limited Board, that would end up in the Crown Resorts Risk and the Risk and Audit Committee, and that would ultimately find its way to the Crown Resorts Board, yes.
Now, Mr Preston gave some evidence to the effect that the executive members of the sorry, I withdraw that. The executives who were members of the Burswood Limited Board had greater understanding and knowledge than the independent directors. Would you agree with that?
Greater knowledge of what?
Of matters that were dealt with in the ERCC.
Yes, they would have.
And to the best of your knowledge, were there any matters that were sorry, I withdraw that question. Can I take you to paragraph 111 of your statement, where you deal with internal audit reports?
I have that.
You say there that internal audit reports went through the ERCC and to the board of Burswood Limited. They also went to the Crown Resorts Limited Audit Committee, didn't they?
Yes, they did.
Who were the people who were responsible for the conduct of that internal audit process?
I can't think of their names now. We had an internal audit team. Ultimately, in recent times, a lady by the name of Anne Seegers was our group head of risk and audit. So this would have been part of her responsibility, and that would follow all the way through the various boards up until the risk committee, and then on to the Crown Resorts Board.
Did you ever have any reason to doubt the competence of Ms Seegers in carrying out her internal audit functions?
No, I found Ms Seegers to be a very, very competent operator.
There was no concerns raised in the board of Burswood Limited about the internal audit, internal audits that she conducted?
Not that I can recall, no.
You say at paragraphs 191 to 193 of your statement that there were some discussions between the gaming, discussions that you had with the GWC regarding modifications to EGMs in Victoria. You have that
In,
passage?
yes, no, I don't. Which one is it? 193?
191 to 193, you refer to those discussions?
191 is China arrests. Are we looking at the same one? 192 is,
Sorry, 190. (192) you deal with Mr Wilkie's allegations,
yes, I do.
and then at 193 you're referring to disciplinary action concerning varying the operation of EGMs without approval.
Yes, yes. Yes, I have that.
Now those matters that you discussed with the GWC there, they did not concern machines of the type that were in use at Burswood, did they?
No.
And you told the non-executive directors of Burswood Limited that that was not an issue in Western Australia, didn't you?
I don't recall that. I'm certain I would have.
Now, finally, in paragraph 53 of your statement, you refer to the board of Burswood Limited setting the strategic direction of the business operated by Burswood Limited, including in respect of the casino. You see that?
I do, yes.
Now, the board of Burswood Limited, to the extent that it was involved in setting that strategic direction, worked within parameters given to it effectively by Crown Resorts and by the executives who were on the board, did it not?
Yes.
And so the independent directors might comment, but ultimately responsibility sat with the executive directors and with Crown Resorts Board.
Ultimately, that's the case, yes.
Thank you. That's all, Commissioners. Thank you.
Thank you. Any other applications? Mr Evans?
If I might, Commissioners. 3 topics. One of them I think will be quite brief. If I can just retrieve a lectern. The others might take us slightly longer. Mr Felstead, my name is Evans. I appear for the Gaming and Wagering Commission.
Thank you.
My learned friend Mr Futrell took you to the concept of cheque cashing. I just want to clarify a couple of matters if I could, to ensure I understood your evidence correctly. The first is that cheque cashing or something equivalent to it was still available at the Perth casino up to the date which you ceased to be involved with the casino?
That is my recollection, yes.
And as you explained it, I took it that cheque cashing facilities were available to domestic patrons, that is, persons who were resident in Western Australia ordinarily.
Yes.
And did I take the tenor of your evidence to be, in substance, a gambler would come to the cage, would ask for an amount of money, would sign a piece of paper which was treated as a promise to repay that money in the future?
No, that's credit.
I understand that, but
Yeah.
to understand what was actually done, they signed a cheque which would be held and which could be redeemed in exchange for a payment made in the future. That was your evidence, wasn't it?
No, not quite, no. I just want to be clear here. I don't want to confuse anyone. We're talking about a cheque cashing facility, correct?
Where the cheque was not actually cashed, is that
Where the
case?
cheque was not actually cashed. The player could redeem that cheque via a telegraphic transfer, via a bank cheque, via cash, or the cheque would be banked.
Was the cheque presently dated or post-dated?
It was dated on the date of the transaction.
But the understanding between the gambler and the casino was the cheque would not be presented for a number of days into the future.
That is correct.
Thank you. All right, can I move on to another topic? There's quite a bit in your statement deals with AML and CTF transactions for understandable reasons.
Yes.
Can I bring up your statement at page 18, paragraph 89?
Which paragraph is that?
89.
89.
The first part of dealing with junket operators and junket players and premium players, and these are necessarily customers who will be bringing in funds generally from overseas, although not always from overseas. is to open a deposit account with the casino cage. That's your evidence in that paragraph.
That's correct, yes.
So that all financial, your words are, so that all financial transactions can be transacted through that account.
Yes,
And that account is maintained in the system which was known as Psycho within the Burswood system, is that correct?
that is correct.
Consequently, for the purpose of the casino's monitoring of the transactions of that player, Psycho plays a central role, does it not?
Yes, it does.
Thank you. Can I take you forward to paragraph 106? And your understanding was that the cage or anyone accepting cash were required to raise a report for any cash transaction exceeding the threshold?
Yes,
And when you refer to anyone accepting cash, were you intending to include within that South Bank Investments and Riverbank Investments?
no, I was referring to cash transactions that may have occurred in the casino. So it may be the cage, it may be at a table game, it may be in a retail outlet. That's what I was referring to there.
Thank you. And that is then consistent with Mr. Preston's evidence, is it not, that South Bank Investments and Riverbank Investments, and this is the evidence, I should say, to the Bergen inquiry, unequivocally, that neither South Bank nor Riverbank had any TTR reporting obligation?
No.
No, in the sense that they did not have a reporting obligation?
No, there was no reporting obligation on those two entities. The reporting obligation was on the casino, either Crown Melbourne or Crown Perth, as a reporting agent, for want of a better word.
Is it the case, and your understanding of the AML program, that on the transfer of funds from the Riverbank account to the cage for entry into Psycho, there was a TTR obligation arising at that point?
No, there was not a TTR obligation at that point, because it didn't involve cash.
Yes, precisely. So for monies which came into Riverbank, there was no TTR obligation, and on the transfer of those funds from Riverbank to the cage, there was no TTR obligation.
That is correct.
And if the funds were aggregated at the point at which they were entered into Psycho, there would be no evident link between the attribution of those funds to a particular patron and the source of those funds at Riverbank, would there?
What that would do, that would void the ability to form rightly a suspect transaction on that matter.
Yes, thank you. So when at paragraph 128 you say that the Riverbank bank accounts were subject to the transaction monitoring program, that was critically dependent upon the accuracy and diligence of the cage team in translating information in those accounts to Psycho,
Yes, it was.
because the entire transaction monitoring program depends upon Psycho.
No, not the entire transaction monitoring program. The manual transaction monitoring programs where at the cage don't, but it is certainly a key element of the transaction monitoring program.
Right, thank you. Can I then take you to a question which you addressed? This was question 37, which was put to you, and you addressed it at paragraph 79. And the question was put in relation to a number of topics: dividends and trust distributions paid by one or more of Burswood Limited or Perth Casino to other Crown Group members, payments and the purpose of payments made to other Crown Group members, and loans by Crown Perth to other Crown Group members. And at 79, in response, you say you had no direct involvement in and no specific knowledge of those matters, and you have no specific recollection of those matters now. Perhaps you could be shown, and I've just lost my computer. Perhaps the operator can bring up CRW 703.001.3302. And can this be brought up on room screens only, please? Now, this is the agenda for a Burswood Limited board meeting.
Commissioners, before Mr Evans continues with his questioning, I can't see the document to which reference is being made.
So can you see it now, Ms Shepherd?
Thank you, Commissioner.
So my apologies. This is the board pack for an August board meeting. I was looking at the attached minutes. Now, I accept that you weren't present at this meeting, Mr Felsted. You're recorded as being an intended apology.
Yes,
But you would have, I assume, have seen much of the contents attached to this in your role as CEO of Australian Resorts. In particular, I'm going to turn your attention to the financial results section, part 2, and the F21-F24 financial plan, including the F21 budget in part 3.
yes,
Now, you would have seen those because ultimately you would have been responsible for the preparation, oversight and delivery of those, would you not?
yes.
So if I can take you down to those. They commence at page 3312 on my heading. And they are very small. And I'll do my best not to read anything in particular out from this because I apprehend that Crown may have some sensitivities in relation to this. But just to understand, this is effectively the consolidated performance statement for the operating entities within the Crown Perth business unit. Is that correct?
Yes, it is.
Now, it's heavily segmented in terms of revenue and expenses by different types of offering.
Yes, it is.
And includes, this is the year to date to 30 June 2020, the budget figures, the actual figures, the variances, and derived EBITDA margins, that is earnings before interest, tax, depreciation and amortisation for each relevant area. Is that correct?
That's correct, yes.
And somewhere in there, recognising that these were likely management accounts and not audited at that August, the best view that the business had of its financial performance for the 2019-2020 financial year in Perth on a standalone basis. Is that correct?
That is correct.
I couldn't identify in here, but there may be somewhere. Is there included in the standalone business unit accounts an allocation for the corporate overheads of the Crown Group attributable to the unit?
I don't believe so. I can't actually recall. I don't believe so. No, I think that was a separate entity under Crown Resorts, I believe.
Right, thank you.
But just on that, sorry to interrupt, Mr Evans, I was wondering, you talked about Crown Perth receiving services from Crown Melbourne, say in relation to international business. So did Crown Melbourne charge Crown Perth for the cost of those services?
To a degree, yes. In some of the shared services, we would have a marketing team over here and a marketing team in Melbourne. Crown Perth would pay for the marketing team located on site, and I believe there would be an allocation of some of the senior management, which would go through to Crown Perth as well.
But it wouldn't be individually itemised on an account as to services,
No.
services provided by Crown Melbourne or anything of that nature?
I don't
Or by-
believe so, Commissioner,
By
no.
head office? or-
No, I don't believe so, Commissioner.
Sorry, Mr Evans.
Not at all, Commissioner. Perhaps I can take you to page 3318. This again is the year-to-date 30 June 2020 actual figures. On the bottom line of that table, which summarises, this is only payroll, one accepts, by effectively sub-unit of the business, regular tables, local premium, which is the VIP business, local VIP business, gaming machines, international business, food and beverage, conventions, hotels, others, marketing, loyalty program, support services. There's a considerable payroll for support services, security, and there's an other expenses corporate, which is actually a negative item. Does that reflect a contribution effectively by Perth Casino to the group in terms of services provided out of Perth?
Yeah,
Maybe Mr McGregor's the more appropriate person.
yeah, no, I think so. I think he'd be better at that. I don't want to put my foot in it or give you the wrong answer.
Thank you. We'll park that until next week. Can I then take you to a more interesting and important topic? I have to page down a fair way, unfortunately. Get rid of that. Can I take you to page 3340? Now, I understand this to represent a balance sheet for the Crown Perth Business Unit as at 30 June 2020. Is that your understanding of what it is?
Yes, it would appear that way.
And in there appear, in the usual way as one finds in accounts, a statement of current assets, including cash held or cash equivalents held, a statement of non-current assets, which includes a valuation for property, plant and equipment. That would be the casino and the hotel buildings and other infrastructure on the Burswood site.
Yes, that would be my understanding. Thank you.
An entry for licences and mastheads, conveniently summarised, parenthetically, the casino licence. So it's an intangible value for the casino licence.
Yes.
Other goodwill, some tax assets. But perhaps slightly more interesting is when I go to liabilities, again presented in the conventional way. There are some current liabilities, as one would expect, trade creditors, people yet to be paid, some tax, some provisions. In non-current liabilities, however, there are three large items. Non-current intercompany payable loan from PBL WA Proprietary Limited. Now, these being consolidated accounts, I assume that PBL WA Proprietary Limited is not a company which sits below Burswood Limited.
I don't believe so. I'm probably not overly familiar with this particular document. It may be a question directed to Mr McGregor or Mr Barton.
All right. Can I take you to the next one? Non-current intercompany payable loan from PBL Finance.
Yes.
Now that's a number which is shown in parentheses. That is, it's a negative liability.
Yeah. I can't shed any light on that.
Okay, we'll pass that to Mr McGregor. But one thing you should be able to cast some light on, perhaps it would clarify, it would assist you if I take you to the bottom of that page, which makes clear that the negative, if you can go a bit further down, operator, bit further, bit further, bit further, bit further. The balances in the non-current liabilities are a loan from PBL WA Proprietary Limited and a loan to PBL Finance and a loan to Betfair. You understand those?
Yes, I can see them. I'm not really familiar with what they're standing for.
Represent. You would be familiar, though, with the cash position of the local group, and you'd be very concerned, I would assume, with its ability to generate and maintain cash.
Yes.
Can I take you to the next page? This is in landscape, so. And can I take you to I won't take you through tediously through each line, but I'll put this proposition to you. Every month or so, when there was surplus cash available in Crown Casino in Perth, it was the subject of what is colloquially known as the Crown Sweep. Is that correct?
I'm not aware of that. That was so I don't want to be evasive here, but this is very much a treasury function. And the first page you took me to, the P&L, I was very much across that. This is probably not my area of expertise.
But it is the position that Crown Perth wasn't allowed to keep more money than was necessary under its control from time to time.
I'm not aware of that.
Right. There's no further point in pursuing that. Then thank you, Mr. Felsted. No further questions.
Mr. Evans, I don't know the answer to this, but I'll put it on the record. People can check. The intercompany indebtedness to a company called PBLWA Proprietary Limited, I think there is a possibility that that's now called Crown Western Australia Pty Ltd.
That is possibly the case. Yes, Commissioner.
Which is interposed, as I recall,
That's correct.
between Crown Resorts and the Burswood subgroup.
And that would make perfect sense, but what it would represent is funds moving up and down from the Burswood Limited level to a level above Burswood Limited, which was ultimately the point of the question. But this is the matter which obviously needs to be pursued with Mr. McGregor next week. Thank you, Commissioners.
Any other applications? Now, I know we have some council not in the room.
I was just miming whether Ms Young was going to stand up before me or not. Commissioners, I apologise for this slight delay. Mr Felsted, my name is Dharmananda. I appear for the Crown Group. I have two questions for you. The first is, you were asked some questions recently about whether certain reports were made by Riverbank or Southbank. Do you know what the relevant reporting entities is for the purposes of the AML legislation?
Yes, it was Burswood Nominees and Crown Melbourne.
Thank you. You were asked a number of questions about the cheque cashing facility, both by Mr Futrell and then by Mr Evans. Are you aware that there is a section of the manual concerned with the cheque cashing facility?
Not specifically, but that would not surprise me.
So, Mr Operator, has CRW.700.001.1250 been uploaded? Does that seem familiar to you, Mr Felsted, or something like it in your time? Did you ever have recourse to the manual at any stage?
I would have looked at the manual at certain stages. I don't particularly recall this, but I definitely would have looked at the manual at some point in time.
Will you scroll down, please, Operator, and you'll see that under the heading Cheque Cashing Facilities, there is a reference to the timeframes for the banking or redemption of gaming cheques presented by patrons, and specifically 5 banking days for local and interstate residents. Do you see that, Mr Felsted?
Yes, I do.
And that accords with your memory of how the facility operated.
Yes.
And to your knowledge, the manual was delivered to the GWC for review from time to time.
That would be my understanding, yes.
Thank you. No further questions.
Thank you, Mr Dharmananda. So no other applications for leave? Thank you. Then Commissioner Jenkins.
Thank you. Just before I start, there was one question from Mr Ward, I think it was the last question, about paragraph 53 of your statement, and I to be honest, I don't think I caught the whole of the question or understood the answer. So I was just wondering if that could be clarified so I could see whether I did have any issue arising from it.
Commissioner, I hate to interrupt. I hadn't appreciated that there was a call for re-examination as well. Is that, if that's the case, then I will be asking questions and seeking leave to do so.
The practice we've adopted is that the commissioners will ask their questions and then you
Okay, certainly. My apologies.
Sorry, Mr Ward.
Commissioner, my question was directed to paragraph 53 and the reference in that paragraph to the strategic direction of the business being set by Burswood Limited. And the question was whether that strategic direction was, to the extent that Burswood Limited was involved, whether that was done within the constraints applied by Crown Resorts at the Crown Resorts level, such that the input from the non-executive directors was, struggling to remember my exact words there, but that the Crown Resorts Board and the executive directors provided that strategic direction, and the independent directors had the opportunity to comment, but it was primarily driven from Crown Resorts Board, and I think the witness agreed with that proposition.
Thank you. So can I ask a follow-up question in respect of that? It's that the Burswood Limited board operated as a board. They weren't separated into executive and non-executive directors, were they?
No, they weren't.
No. So whatever direction they gave in respect of the business, they gave as a board rather than as some directors having greater power or power of direction than other directors.
That's correct, Commissioner.
And whilst you're a member of the board, did they operate in practical terms as two different groups?
No, they didn't, Commissioner.
In respect of the International Commission business, I want to put to you some things which Mr Bossy says about his involvement, because I'm not quite sure that he and you are on the same page, so to speak, and I want to get your comment about what he says. So he says that he made you, and you were CEO of Crown Perth at the time. He commenced working for Crown in Perth, aware of the limitations of his knowledge with respect to ICB operations. Would you agree with that?
Yes, broadly, yes.
And he says that his operational involvement in ICB was limited. Would you agree with that or not?
Yes, he was involved, but not as much as mine, definitely.
And he says that ICB largely operated from CRL and Crown Melbourne. Would you agree with that?
Yes, I would agree with that.
Now this is, in particular, I want to ask you about this. He says that he had oversight of the members of the international team at Crown Perth until around mid-2013. I understood your evidence today was that you would put a different date on that.
Yes, I don't accord with Mr Bossy's view on that. I don't. That would suggest that he had it, then it was taken off him. Is that the thrust of that?
The point was more. Thought that your evidence was that it was from 2016 that you took, or that the ICB business was really taken away from Perth, if you like, and centralised in Melbourne.
Elements of that were, Commissioner. We had a head of international, I think it was a vice president of international, who was, I guess, the manager on the ground up until 2016. Then he left the business. Then it became a function of Crown Melbourne.
He then goes on to say from mid-2013, Mr Felsted became the CEO of Australian Resorts and he assumed direct responsibility for ICB. inclusive of VIP and junket operations across the entire Crown Resorts Group. Now, my understanding of your evidence was that that occurred from 2016, not from mid-2013. Am I right in that, or am I wrong?
That is wrong, Commissioner. It was definitely 2013.
2013. So you and Mr. Bossy agree that it was mid-2013?
Yes, I apologise if I led to believe something else, but it was definitely from 2013.
So at paragraph 85 of your statement, you refer to 2016, and for example, you say from 2016 the ICB, with the exception of hosting and on-the-ground servicing of customers, was run out of Melbourne.
Yes.
So I'm still confused, Mr.
No,
Felsted.
I probably have confused you. In 2000, and if we pick a date, in 2015, as an example, we had a head of VIP who was based in Perth, and that particular person would look after the hosts in Perth, he had some degree of responsibility for credit control, and he was working in conjunction with the team in Melbourne. Come 2016, that position no longer existed, and all the functions there, including the hosting, apart from the staff on the ground, reported through to Melbourne.
Well, I thought you'd agreed with Mr. Bossy just a moment ago when he says that from mid-2013 you assumed direct responsibility for ICB inclusive of VIP and junket operations across the entire Crown Resorts Group. So I suppose that's in terms of management.
That's in terms of overall responsibility. So I guess I was here and I was overseeing the entire ICB operation. Mr. Bossy was assisting on the ground with the people that were here.
So if he gave evidence that he really had nothing to do with it from 2013 apart from the hosting and some extension of credit, would you agree with that or not?
Yes, I would agree with that. I think I made an error here. The VIP management team in Crown Perth reported to COO. That may not have been correct, so apologies for that.
Now, in relation to China, you said in evidence today that maybe, well, I'll just put to you what I heard. I heard you say, in answer to a question from Mr. Futrell, that Crown did not have an overt presence in China in the sort of around 2015 time period. Did I hear you correctly?
I may have been referring to we were not operating in an overt manner. We had a presence in China, definitely. We didn't have an office. We didn't have any shop fronts in there. It was staff based in China, working in a low-key manner. I think that's what I was trying to allude to.
So you consider having over 15 staff members in mainland China whose job is to market Crown casinos to Chinese nationals and whom have budgets which they are encouraged to meet and or exceed in terms of marketing, is not having an overt presence in China?
I would say we had a strong physical presence in China. I guess I was referring to more about the activities of the people there from an overt manner. But we definitely had a strong presence in China. I won't deny that.
Were they being encouraged to conduct their employment conduct on the quiet because Crown knew that it was not legal in China?
No.
In respect of ICB business, it seems to be accepted by everybody that providing credit is a necessary part of that business. Is that your understanding too?
Yes, it is.
Why is that?
It's something that is done. All major casinos that I'm aware of that deal in the ICB business, and some of them don't. They all provide credit. It started in Vegas many, many years ago. Most of the other casinos have followed suit, and it's just an accepted practice in the business to provide credit.
Tell me, are they charged by Crown? Was interest charged on the debts?
No, it was not, Commissioner.
So it's an interest-free loan, in effect.
Yes, you could describe it as that.
And I think you would be aware that under the state agreement, providing credit to gamblers is in WA is prohibited unless it's with the consent of the GWC, the prior consent of the GWC.
Yes, I'm aware of that.
Or its equivalent. Now, when you joined Crown in Perth, had that standing permission or consent already been given?
No, it had not. That was, I believe that was approved at a later date. I started in 2005. Credit was not, I don't believe it was available to overseas customers then. It was approved at a later date.
And did you have any involvement in that process?
I don't specifically recall. I may have.
In respect of credit being given to Chinese gamblers in the 2010s and after that, you were aware that recovery of debts from gambling was illegal in China?
I wasn't aware it was illegal to recover a debt in China.
So if that's what the Bergen report reports, you would say you weren't aware of that?
I wasn't aware it was illegal, no.
You, in answer to a question from Mr. Futrell, you disagreed with him that getting Chinese gamblers to exceed the limit of money they were permitted to take out of China for gambling was a key factor. But in actual fact, that answer you gave to Mr. Futrell wasn't responsive to his question, as I understood it. My understanding was he asked whether you acknowledged that Crown knew, or you knew, that you were facilitating patrons breaching Chinese law, that is Chinese patrons breaching Chinese law by taking money out of China for gambling.
Sorry, I just missed the question.
Do you know, and did you know, sorry, I should put it in more timely fashion, did you know back in 2015-16, the relevant period, I think is how it's been described, that Crown was, by various methods, by use of the Riverbank account, by the CUP process, facilitating patrons breaching Chinese law by taking money out of China for gambling?
No, I didn't make that distinction that we were facilitating breaking Chinese law.
You were a member of the VIP working group or the VIP review working group that it has been called variously.
Yes, I was.
And wasn't or was it a purpose of that group to explore ways in which Chinese gamblers could remit money from China to Crown for gambling?
Yes, it was.
And wasn't that an issue because you knew and Crown knew that Chinese gamblers, Chinese residents, were not permitted to take money out of China for gambling?
It wasn't so much they weren't permitted to do it, Commissioner. It was more the difficulty the customers were expressing to us in the repayment of debts when they were in China. Some of these customers would have had accounts overseas. We were just trying to explore ways, were there any legal ways that money could be moved from a customer perspective.
And wasn't that because they could not move that money lawfully for the purpose of gambling out of China? And didn't you know that?
Well, I did know that there was restrictions around currency out of China. I didn't turn my mind to that particular issue per se, but that was always an issue for us, getting customers to pay their debts from China.
In respect of the CUP process, you said that you thought that the advantage of CUP was because that there was a limit on the withdrawal of money within 50 metres of a casino or something of that nature, the casino floor. Was that the effect of your evidence?
I mentioned that, Commissioner, in relation to why it was done at the my understanding of why it was done at the hotel.
The purpose of doing it at the hotel, was it not, was to disguise the fact for the Chinese patrons that they were moving money out of China for gambling.
No, the purpose of doing it at the hotel was you couldn't do the transaction at the casino cage.
In respect of the Riverbank account, you gave evidence about people in Perth who knew about the account. A different question is who in Perth would have seen the transactions within the account. And can I ask you that question? And I think to some extent it might be reflected in an answer you gave Mr. Futrill, but just remind me again who, in your view, in the period of 2013 to 2017-18 would have seen the transactions through the Riverbank account?
In Perth?
In Perth.
That would have been the cage personnel, typically cage management. That would have been the finance department, and they're the only two I could think of that would have seen them in Crown Perth.
Sorry, my mind wandered there for a moment, Mr. Felstead. So the cage staff.
The cage staff, yes.
Mr. Brown was manager of the cage?
Yes, he was, yes.
So would he have seen the transactions?
I would imagine either he or he would have delegated to people within his team.
His team. What about Vasula Kessel?
Vasula or her team would have been looking at the accounts, the specific transactions going into the accounts, yes.
Now, you were referred to some evidence given by Mr. Brown at the Bergen inquiry, and you said in an answer to Mr. Penglis that essentially you disagreed with Mr. Brown that staff within the cage should have been checking the Riverbank account for suspicious transactions. Is that right?
Yes, I said that staff in the cage should have been checking for suspicious transactions.
So we've got a situation where Mr. Brown says they weren't checking. You say they should have been checking. Doesn't that highlight the importance of actually ascertaining who these people were and finding out whether they saw the suspicious transactions and deliberately aggregated them, saw the suspicious transactions and didn't realise they were suspicious, or had some other explanation for what occurred?
Yes, it does. An investigation needed to occur.
And by the time you left Crown in the end of 2020, had that investigation taken place?
I don't believe so.
And so you certainly cannot tell the Commission why those suspicious transactions which have been identified in Riverbank occurred. Or, sorry, I shouldn't say that. That's wrong. You can't tell us why they were not identified by Crown's staff and reported up the line.
I can't give you an explanation of that.
In respect of the closing of the ANZ account, why didn't you ask why the ANZ account was closing? That is the Riverbank Investments account.
With the banking and the Treasury Department, that was just not something I turned my mind to, Commissioner. I had, and this is not trying to make excuses, but I looked after certain issues, other people looked after others, and that was not something I did.
2014, this was a time when you were on the VIP review committee, wasn't it?
Yes, that would be correct.
And it was, you've agreed that it was a part of that group's purpose to assist overseas patrons to remit money to Crown for gaming, wasn't it?
Trying to find ways to do that. Yes, that was one of the purveyors of the committee.
And the Riverbank account was one of the ways that overseas patrons could remit money to Crown for gaming in a way that suited them because they didn't have to reveal that it was for the purpose of gaming.
Correct.
So doesn't it seem surprising to you that you didn't ask and weren't concerned about the fact that the Riverbank account was being closed? Because this was closing off one of the ways overseas patrons could remit money to Crown for gaming.
I think the key issue, Commissioner, was not so much the existing accounts we had, which included Riverbank and other accounts. It was more about what are other ways we can find for patrons to remit money to the property.
You want to expand the ways. You'd be very concerned if they were contracting.
We had a problem, as I mentioned earlier, we had a problem with customers getting money to pay debts, and we were looking at other ways to do that.
In a well-managed, oblique-governed operation, would you expect that you as CEO of Australian Resorts would have been told that the Riverbank Investments account was being closed by the ANZ because it recognised transactions within that account, that is, suspicious transactions which raise questions as to whether money laundering was occurring in that account.
I think in an ideal world, I would have been told a lot of things.
And that then the relevant governing boards would have been told as well. Do you agree?
I would agree with that, yes.
And if Mr. Preston and Mr. Bossy and Mr. Barton knew that that was the reason why the ANZ account was being closed, you would have expected them to know that it was appropriate to report that up the line to you?
Yes, yes.
And so do you acknowledge that if they did know that their failure to report it up the line to you reflected poor AML policy or implementation of policy within Crown at that time?
I think what it reflected, Commissioner, was probably there was a siloed effect in terms of who was responsible for what, and I think that may have been to the detriment of some of these things.
In respect of the reduction in the speed of play from 5 to 3 seconds, you gave an explanation as I understand it. You were saying that in your view it wasn't a reduction in speed of play from 5 to 3 seconds, it was a reduction in speed of play from 9 seconds to 5 seconds or something to that effect, is that right?
Words to that effect, yes.
So can I just understand this? Is that I've got $1 and I put it into the machine and I press a button, that's my commencement of play.
Yes.
And when do you say the next, when does the play finish?
When the symbols stop rotating, spinning, whatever it might be.
Right. And there then may be features and bonuses which mean that I don't play a new game for 9 seconds. Is that what you're saying?
Or longer, Commissioner, yes.
So I don't put another $1 in if I'm theoretically...
If you're lucky, yes.
For 9 seconds.
That's sorry, Commissioner, that's on average. It could be a minute, it could be 2 minutes.
So what I don't understand, if that is how the machine operates, why do you need to get permission to reduce the speed of play? Because what you're saying to me is that the features you've introduced into the machine or the manufacturers have reduced in the machine mean I can't play the machine quicker.
I think it's a bit of a technical issue. It involves when you don't get a feature on the machine, it'll go from 5 seconds to 3 seconds, but overall it averages out at 5 seconds plus.
So over what period of time does it average out?
Over thousands of events. Thousands and thousands of events.
Now can I put this to you, that the explanation you gave does not say why there would be no impact on gambling-related harm. Rather, it says why it's not a harm caused by reduction from 5 to 3 seconds, but in your view, harm caused by reduction from 9 seconds to 5 seconds. Do you understand what I'm saying?
I think I do. The statement I should have made in the letter to Mr. Ord was a minimal or negligible as opposed to no, so that was incorrect, and I corrected that in my presentation. It's a very, very hard one for me to explain. On the machines at the moment, so if I go back, this may make it a little bit simpler. If we had every machine in old format and they had no features, no free games, no jackpots, and every machine was regulated at 5 seconds. So you press the button, something occurs, some cards get dealt, whatever it is, you can't play it again till 5 seconds. If we went and turned every one of those machines into a 3-second game, that would have an impact on RSG. That would have a negative impact on RSG. There's no doubt about that. The fact is, the older machines, we weren't planning on converting them into 3-second games because you can't get the software to do that. So the 5-second games typically would stay at 3 seconds. This is just in relation to new games, and part of the issue that the manufacturers are doing, more and more games, they're having more and more and more features on them. So you could see 5 years ago, a feature may last for 30 seconds. Some of them now will last for 2 minutes, 3 minutes. So it's more the nature of the ongoing development of the machines.
What I'm putting to you is that any decrease in play will result, or any decrease in speed of play will increase gambling-related harms. Isn't that correct?
Yes, that would be correct.
And in respect of this particular proposal, did Crown get any independent advice as to the effect on harm which was likely to be caused by the change before they went to GWC and asked for it to occur?
No, we did not, Commissioner.
Thank you.
I'm conscious of the time. We have an issue with the transcribers, so I think my questions can be directed to other witnesses, so I won't take up time. But will I call on Ms. Shepherd to? Ms. Shepherd, do you wish to re-examine?
Yes, thank you, Commissioner. I have 4 topics for re-examination. If I might take up Commissioner Jenkins' topic first in relation to EGMs. Can I, EGMs and responsible gaming. Can I ask the operator to bring up CRW.709.132.6302? And that's the letter dated the 7th of March 2019, addressed to Duncan Ord, from you, Mr. Felsted. Do you recall being asked questions about that letter earlier?
Yes, I do.
You were asked questions about the comment that you made on page ending 6308. At about a third of the way down, and you've just referred this to this comment in your answers to Commissioner Jenkins about it not having any impact on gambling-related harm. Do you see that?
Yes, I do.
Which you've indicated you corrected in a presentation to the GWC. Before we get to that presentation, can I ask that the operator turn to page ending 6306? And about 4/5 of the way down, there's point 5 and a paragraph commencing, further it is understood. Do you recall in the course of giving evidence, you referred, Mr. Futrell, to an earlier part of the letter in which it was set out that the impact of these EGM product developments is such that currently the actual EGM game speed at Crown Perth, allowing for all forms of incorporated game features, is approximately 9.5 seconds, and that it would be sought to be reduced to 5 seconds on average If you go to point 6 and then over the page ending 6307, you can see that. If the operator could turn to the following page.
Yes, I do see that.
Is that the part of the letter that you're referring to in your answers to Mr. Futrell earlier?
That was.
Yeah. And can I now ask that the presentation be brought up, and that's GWC.0016.0269. That's the PowerPoint of the presentation given to the GWC on the 26th of March 2019. Do you recognise that document, Mr. Felsted?
Yes, I do.
Yeah, and that's a presentation that you attended at the GWC?
Yes, I did.
Yeah. Could I ask the operator to now turn to page ending 0284. If there's not a page numbering on it, it's the PowerPoint heading responsible service gambling. And you see there, it says negligible impact in respect of gambling related harm for the following reasons.
Yes, I do.
Is that what you were referring to when you said to Mr. Futrell that you had corrected your assessment of the impact to negligible?
Yes, yes, it is.
And can you see below that the explanation given to GWC as to the reasons for why the impact would be negligible is based upon the average speed of paid EGM games expected to remain above 5 seconds. Do you see that?
Yes, I do.
And you set out there the reasons why Crown came to that view.
Yes, I do.
And so is it the case that in terms of representing the potential impact on responsible service of gambling, you were making representations as to the impact arising from the current standards being 5 seconds and not the creep of the additional increments in time to 9 seconds being lowered to 5 seconds?
That is correct, yes.
I'm sorry, Ms. Shepherd. While that's on the screen, how do you read grammatically? How do we read that last bullet point? Is it low proliferation single site and low rate of problem gambling?
Yes, that should be in there, Commissioner.
Mr. Felsted, do you recall being asked by Mr. Futrell about the use of CUP cards at Crown Melbourne, and also being asked about the same issue by the Commissioner just now?
Yes, I do.
Do you recall it was suggested to you that a patron with a CUP card would present it at the hotel for it to be recorded as some other transaction to avoid it being displayed as a purchase of chips or for gambling? Do you recall that question put to you?
I do, yes.
And do you recall answering that you recall seeing sometime later a document which indicated it was recorded as a caged transaction?
Yes, I do.
And it was also suggested to you that CUP would be presented at the hotel away from the casino, suggesting that it was to hide the nature of the transaction. Do you recall that?
I do, yes.
And you answered that you thought it might have something to do with the casino regulations requiring withdrawal of money 50 metres away from, or withdrawal of any sort 50 metres away from the casino. Is that correct?
That is correct, yes.
Can I ask the following document to be brought up, which is CRW dot 523 dot 002 dot 0001. That's a document headed "How to Process a Main Cage Purchase for a Gaming Guest." Do you see that?
Yes, I do.
And about halfway down the page, there's a heading "Scope," and it talks about the procedure applies to front office supervisors and duty managers who receive a request to process a main cage purchase. Do you see that?
Yes, I do.
And can I ask the operator now to turn to page ending 0002? I'll take you to 0004 first. And you see up the top, step 5, the first bullet point, there's an instruction to those processing such transactions to process the payment on the guest's account using code 922 main cage payment NAB. Do you see that?
Yes, I do.
Was that what you were referring to when you said that you had recall seeing a document which indicated that it was recorded as a cage transaction?
Yes, it is.
And is there any reason to think that the bank would not know that that was a transaction to purchase chips at the cage of Crown Casino?
No, there was no reason they wouldn't think that.
And can I ask the operator to turn back up to page 0002? And scrolling down the page, down the bottom, there's a note. And you see there it says, when processing the transaction in Crown Towers, it must be done on either the second or third terminal from the right when standing in the lobby looking towards the reception desk. This is due to legal reasons relating to proximity to the gaming floor. Do you see that?
Yes, I do.
And was that the requirement that transactions be at least or more than 50 metres away from the main gambling floor?
That is correct. That is correct.
And that's a responsible service of gaming measure, isn't it?
Yes.
Now, you said you recall seeing this document later. Was that after you left the employment of Crown?
I believe so, yes.
Yeah. And this was not a document that you would have had close knowledge of at the time of your employment. Is that right?
No, the process was started before I had involvement in this particular part of the business.
Nonetheless, do those matters roughly accord with your view at the time that CUP was not being used to disguise the transactions being conducted?
Correct.
Yeah. You recall that you were questioned extensively about your evidence that the use of the name Riverbank Investments instead of Crown on bank statements was affording patrons their privacy. Do you recall that evidence?
I do.
And you said that it was a long-standing practice amongst most, if not all, casinos to provide such bank accounts. Is that right?
That is correct.
Yeah. And is it the case that the practice arose at a time when there may have been a stigma or a moral taint associated with spending money on gambling, or that it might raise questions about a person's character if money was seen to be spent on gambling?
Yes, that was the case back in the day.
And you can think of other industries, can't you, Mr. Felsted, where cash might be used for a service with a moral taint, but if a credit card or similar was to be used, then the person conducting the transaction might not want to have that displayed on their bank statement.
I could probably turn my mind to a few industries like that, Ms. Shepherd.
And it might be that the person may not want to have the bank statement with that detail shown to, for example, their wife or their family members. Is that right?
I think that would be a very, very valid reason.
And do you recall agreeing with the proposition that by not using the name Crown in the transaction, Crown might be facilitating the patron hiding the transaction from other people?
Beg your pardon, could you just repeat that question, please? I didn't quite catch that.
A proposition was put to you that by Crown allowing patrons not to use the name Crown in the transaction, that the patrons might be hiding the transactions from other people or third parties.
Yes.
And that Crown was facilitating that. Do you recall that
Yes.
proposition being put to you and you agreeing with it?
Yes, I do.
Which of these other people did you have in mind when you agreed with that proposition?
I was primarily thinking partners. I was thinking someone at the bank. That sort of work.
Are not illegal authorities then?
No, that wasn't part of my thinking around that.
Now, do you recall that you were questioned extensively about why you personally did not take steps to investigate transactions on the Riverbank account in the period from August 2020, in the time after Josh Preston gave his evidence at the Bergen inquiry? Do you recall that evidence?
I do.
And do you recall yourself giving evidence at the Bergen inquiry in about August 2020?
Yes, I do.
Yeah. Now, would it be fair to say that the aftermath of giving evidence in the Bergen inquiry, that affected your standing at Crown?
Yes, it certainly did affect my standing at Crown.
Yeah. Well, it's the case, isn't it, that you left the organisation on the 31st of December 2020, but your departure was announced some time before that. Do you recall that?
Yes, my departure was announced in the inquiry.
Yeah. That was in mid-November 2020, wasn't it?
I think it might have been a little bit earlier than that, Ms. Shepherd.
It may well have been. Would it be fair to say that you were managed out during that period?
I think it would be fair to say that there was no longer a position for me. I was made redundant, and along with Mr. Preston.
So can you please explain to the Commission what practical authority you had in the months of September, October and November to instigate investigations into financial transactions of Crown?
I think it would be safe to characterise my activities during that period. I was sidelined. I wasn't included in things. It was just I was biding time. I think it was the best way to describe that. So I was not included in activities, in meetings and the like.
Thank you. No further questions.
Thank you very much, Ms. Shepherd. Mr. Felsted, there may be some tidying up for us to do, so I'll leave the summons in place, but you're free to go and you have our gratitude. Thank you very much.
Thank you to the Commissioners and thank you to everyone in the room. Thank you.
Thank you. And we'll adjourn to 10 a.m. on Monday.
All rise.
So does now get to charge Western Australian rate for doing it virtually?